We're now looking at the tort of negligence as the first category of tort. So the tort of negligence is the one that has the greatest impact on construction. And the reason that I say that is because there's a lot of incidents and a lot of injuries that take place on a construction site. Most of these injuries are a result of negligence by one of the parties that were responsible for ensuring that there was reasonable care in performing certain activities on a construction site. How do parties avoid negligence? Well, it's based on ensuring that reasonable care is exercised to prevent damage from occurring to others when engaged in an activity. Now, to a reasonable person, this activity has to be realized as one where it initiates a requirement for careful performance of that activity. Now, in the tort of negligence, there's no need for a contract to be established between parties for you to be able to bring a case in tort against a party that commits the tort. So it's all based on foreseeable harm. So the party that commits the tort, were they able to foresee a particular harm associated with that activity? And if they were able to foresee that harm, did they take all the reasonable measures that were necessary to ensure that the activity was performed with reasonable care? So these are some of the questions that a court would ask to determine whether negligence had occurred or not. And when it comes to construction, what are some of the examples as to where negligence would arise? So I've listed a couple of here for you. Uh, Cases between a client and a builder. So a client engages a builder, and a builder does something which is negligent, delivers a certain um, part of the building, but it do, they do that in a negligent way, such that you have maybe cracks occurring in your concrete structure. So that would constitute negligence. If the builder fails to follow the working methods that have been specified in the NCC, so they don't do it in a safe way, for instance, or if the builder fails to follow legislation, ONH legislation, so occupational health and safety legislation, if they fail to follow that or the rules that are specified in such legislation, then that can constitute negligence. You also have cases where your consultants can be found to be negligent, and an example of that would be, say, for instance, an electrical engineer that recommends the wrong voltage system, and that leads to damage of certain equipments that utilize, the electrical system. The electrical engineer can be found to be negligent over here as well, in a case that is raised in torts. What happens if the parties have a contract between them? So if two parties, there was tort, a tort was committed by one of the parties, but there was also a contract that had been established between the parties. Should the injured party bring an action in tort, or should it bring an action in contract? The easiest, of course, is to bring an action in contract. Why is that the case? Well, it's because it's easier to prove that there was a breach of the reasonable care and skill provision that is usually implied in contracts. It's easier to prove that than to prove negligence. Now, to prove negligence, there's a lot of different elements that the plaintiff has to show evidence of. And this is what I'll be discussing on this slide. So some of the elements, or all of the elements that you need in order to establish an action for negligence in tort, these are given on the slides over here. So the plaintiff, the person injured, must establish that the defendant owed them a duty of care recognized by the law. So the plaintiff over here, the injured party, has to establish that the person that committed the tort, the defendant, owed them a duty of care. So the duty of care must have existed, and that duty of care must be recognized by the law. The second element is that there was a breach of the duty. So first element, the plaintiff establishes that a duty of care existed. Second element, that this duty of care was breached. And the third element is that the damage that was suffered by the plaintiff was directly due to the breach of duty by the defendant. So these are the three main elements. Some other uh, some other aspects that the plaintiff has to have into consideration. Number one, there has to be a reasonable proximate connection between the action of the defendant and the damage that's done to the plaintiff. So it can't be very disconnected or very far apart, such that the court wouldn't be able to determine the connection between the action of the defendant that led to the damage uh, that took place for the plaintiff. Another aspect that the plaintiff has to consider is the fact that they need to counter defend. So they need to counter any defense that's raised by the defendant. An example over here would be, let's say the plaintiff is claiming that there was a duty of care that the defendant owed them, and then in response, as defense, the defendant says, well, there was a duty for the plaintiff to take reasonable care when performing the action or when undertaking a particular risky activity, but they failed to take that. They failed to consider that duty. The plaintiff failed to consider that duty, and that would be like a defense for the defendant. It has to be countered by the plaintiff, so the plaintiff has to show that they took all reasonable measures to make sure that they were performing the activity uh, in as much care as was possible or as was evident to the plaintiff at that moment. So that's another important aspect, providing a counter defense or providing a counter argument to the defense that's raised by the defendant. But the three main aspects that you have to consider when it comes to bringing an action in tort, particularly negligence, is that the plaintiff has to establish the duty of care, the breach of duty took place, and because of that breach of duty, there was a damage that was caused to the plaintiff.